But before the coffee break, we're coming back to the question of alternative sources of finance. Many of you, of course, are familiar with Peter Jago of MFB, who usually comes down to this conference. He's not here this year. In his place is Jonathan Watson, who's going to speak on the topic of alternatives to traditional bank finance, and interestingly, reviving something I remember from the 80s, the topic of joint ventures.
Hello everyone, my name is Jonathan Watson and I'm from MFB Solicitors, and may I say what a pleasure it is to be invited here today to talk to you on this topic. We act on a variety of non-contentious and contentious shipping matters, and over the years we've seen joint ventures arise in all sorts of shipping contexts, from land reclamation projects to port agency JVs, pollution cleanup services, transshipment activities, platform supply functions, vessel construction projects, and so on. My presentation today is about the financial aspects of joint ventures, and I'd like to start by answering a question that some of you may be asking yourselves at this moment. Which is, keep you in suspense, which is, why is someone more likely to finance your business as an active participant in it, that is, as a co-venturer, than a commercial lender, such as a bank? And the answer to that question, and I leave aside for one moment current market conditions, the impact of which has caused some banks to withdraw from ship-related finance anyway for policy reasons. Leaving that to one side, the answer to that question lies in the way that banks and co-venturers assess project risk and return, and that applies both at the time of the initial advance and later should further funding be required. In making its decision to lend, a bank will focus on issues such as credit risk and security, asset valuations, balance sheets, internal rates of return, and so on. But a co-venturer will focus more on the underlying business and may have a better understanding of that business if it is actively involved in it already than a commercial lender. So in doing that, they may see advantages to their involvement in your business that may not be of interest to, or indeed of any relevance to, a bank. Your project might introduce them to new business areas, clients, or jurisdictions that they have been unable to access in the past. It may offer them tax or accounting advantages, economies of scale. It may offer them the opportunity to utilize assets that are currently underused. And if these or other business advantages exist, a private investor may see its investment as financially more worthwhile than a commercial lender, and so may expect less in terms of valuations, due diligence, security, and so on, as a precondition of its finance, and that in turn may make the deal more likely to proceed, possibly shorten the time it takes to complete, and possibly reduce the transaction cost. And moreover, if a bank approves the loan, then the continuation of the facility will often be made conditional upon your compliance with a package of financial and other covenants that together allow it a reasonably wide discretion to withdraw the facility if they see a reason to do so. A private backer with a participation in the business may view the continuation of that business more as a matter of common interest. So if further funding is required and the backer remains convinced by the underlying business, and it has the resources, of course, then it may adopt a more accommodating attitude to further funding. So very briefly, how does a business collaboration or joint venture come about? Well, a joint venture is any commercial arrangement where two or more economically independent entities participate together to share the risks and rewards of a joint enterprise. So as you can imagine, that description covers a broad range of business relationships and purposes. The classic example in the shipping sector, of course, is the pooling arrangement, where two or more ship owners pool their vessels and resources in relation to a particular route to lower operational expenditure, spread the cash flow risk, gain better access to facilities and better terms for their suppliers. But other examples might include what I call demand-side joint ventures. So here you may be talking about charterers with significant tonnage requirements investing in their carriers. That may be to hedge against increased rates when market improves and possibly to share in any capital gain made by the sale of the underlying assets whenever that takes place. Or supply-side JVs. And this is where ship owners may invest in their suppliers, their critical suppliers such as local port agents, or people in their supply chain such as overland hauliers, both to secure the continuation of that supply and possibly preferential access to it, and to lower their overall costs. You also get project-based collaborations where parties tender together for and then perform together a particular project, and that may be because that project requires a significant amount of capital assets and technical expertise to perform. So you often see that in large infrastructure projects, you see it a lot in salvage projects and that sort of thing. Now, if you bid together, then you're more likely to get the award because together your combined resources make you a more technically and financially substantial bidder. And if you get the award, then of course you can syndicate the risks involved. You also get JVs occurring because they have to. An owner may have no choice but to work with a local partner because local laws restrict foreign investment or the operation of companies and vessels by foreigners in that jurisdiction. So, for example, those countries with cabotage restrictions. Whatever your venture, no private lender will advance funds and become involved without being reasonably satisfied about the risks involved, and that comfort can be obtained through a properly structured and documented cooperation arrangement. So what are your options in terms of putting that structure in place, and how will you make your decision? Well, to a large extent, this will depend on how you answer the various questions that I've set out on the slide as the headline issues. Firstly, of course, how many parties will there be in the venture and what will their respective shares be? A 50-50 joint venture with no one having overall control is going to behave very differently. It's going to be documented very differently than one where a party has overall control, or one where three or more parties are involved, or one where of those two or more can exercise overall control if they act together and they're expected to do so. How will the parties work together in the decision-making process? Normally the joint venture agreement will provide for this so that certain decisions can only be taken with a majority or perhaps unanimous decision of the venture participants. It will also provide usually for what happens if that unanimous decision cannot be reached. Possibly it may be that the majority participant has the final say, or maybe even that the venture is dissolved on pre-agreed terms. How are you going to get your venture where it needs to be to start it up in terms of customer contracts, licenses, employees? Of course it will need finance, but what about these other pieces of the jigsaw? How is it going to get all of these items? Will they be provided by the venture participants? In whose name will they be owned? Will they be used exclusively in that business? And will whatever is contributed be returned after the venture has run its course? What are your responsibilities to the JV going to be? Are you going to have to use that venture if you have business that venture can deal with? That is, will it have exclusivity over the sort of business that you have in that jurisdiction where you've set up your venture? Also, what about extra cash? What if your joint venture runs out of money? Do you have to fund it? Usually, joint venture agreements will provide a mechanism to allow one or both parties to provide additional venture finance if required, and if one party funds and the other does not, then for the parties' respective participations in the business to be restructured until such time as the position is back to normal. And finally, exit. Crucially, how and when do you expect to exit your venture? A properly drafted JV agreement will provide for a mechanism to allow the parties to undo their arrangements at a predetermined time. It may be that after a certain period, one or other party is entitled to sell its share of the business to its co-venturer for a pre-agreed price. Or it may be that the JV is for a specific project, and on expiry, one or other party has the right to buy the venture assets for themselves, or a broker is appointed to sell them for the best achievable price and divide up the proceeds. There may be circumstances where you require the venture to be dissolved before it has run its course. And a joint venture agreement will normally provide for these as well. For example, if one party is in material breach of the agreements or suffers an insolvency event or changes control. Whatever is agreed for either a voluntary or compulsory exit, the parties should have regard to what the venturers have put in, what they hope to get out, and over what period. Very quickly, what are the common forms of a joint venture? Well, you can have a joint venture company or corporate JV. That's where a company is set up. It owns it runs the business, and you own shares in that company in agreed proportions. So the joint venture is a company, is a separate legal entity. It can contract in its own right, own assets, soon be sued in its own name. Critically, the shareholders, that is the joint venture parties, will not be liable for the debts of the company, because usually companies are set up on a limited liability basis. You're not liable as shareholders unless you specifically agree to be so, for example, if you guarantee the debts. The other option is a partnership. Unlike a corporate JV, a partnership is not a legal entity. It's the legal effect of a business relationship between two or more parties. And in the UK, that relationship is defined as one which exists between persons carrying on a business in common with a view of profit. And that relationship comes with it certain legal rights and obligations which, depending on your jurisdiction, often mean that each partner is jointly and severally liable for the debts of the partnership. And finally, you have a contractual joint venture. And that arises where one party agrees with another to treat certain assets and business as being subject to their joint venture arrangements. They contract to receive and divide up the proceeds and expenses of that business in agreed proportions and subject to agreed terms. And you also get hybrid arrangements which have some features of these models and some features of others. So you may get a model that is organised along the lines of a partnership but has limited liability and separate legal identity like a company. How to structure investment in the JV? Well, if your collaboration is through a JV company, then finance could take the form of debt or equity. We've already heard about equity finance and how that will involve the company issuing shares to you and receiving payment in the form of your subscription monies. And those monies can be used for working capital purposes in such way as the company sees fit. Debt, on the other hand, will involve you lending monies to the JV company against the company's obligation to repay, and subject to the usual provisions regarding interest and events of default. The main advantage of equity finance is that, of course, you participate in the profits of the business. The main disadvantage is that only happens if there are any. And if the business does not succeed, and particularly if it does not succeed for reasons of insolvency as a shareholder, you will rank in most jurisdictions behind almost everyone else in terms of priority of payment. So on an insolvency, you're almost certainly going to get nothing. But the risk there for a financial backer in the form of someone actively participating in the business is at least managed, because you will be, depending on what your JV agreements say, but more than likely, you will be involved in the running of the business. You may have a seat on the board of a joint venture company. That a joint venture agreement will require certain decisions to involve you as a board representative, and that gives you some comfort that as long as it's within your power, the business will proceed in the ordinary and normal course. So just to conclude, the focus of this presentation has been about joint ventures as an alternative to bank finance, but they can also be a means of accessing that finance. DVB Bank were quoted in Lloyd's List last week as saying that there were too many small and medium-sized ship owners looking for finance, particularly in Greece, where domestic banks are now out of the market following the financial crash and Eurozone crisis. It's not that banks are not willing to lend to smaller owners, but the risk is spread with a larger fleet. And DVB Bank urged smaller owners to pool their resources to create a critical mass in terms of fleet size. A business with 10 or more vessels will be more attractive to a bank than one with only 2 or 3. So a JV does not have to be an alternative to plain vanilla financing. Sometimes a JV with another owner can be the means by which that financing can be obtained. Many thanks.
Thank you very much, Jonathan. Now we have the last coffee break, and then we will have the last session, very interesting. We'll have the debate on